Dear viewers, I am Professor Sharanjit from the Rajiv Gandhi National University of Law, and in this session we shall be talking about the vicarious liability of the state. We shall start today's discussion with the words of Salmond. Salmond said, "In general, a person is responsible for his own acts, but there are exceptional cases in which the law imposes on him vicarious responsibility for the acts of another, however blameless himself. Thus, normally speaking, a man is liable for his own acts or omissions, but there can be certain circumstances in which a person is held liable for the wrongs committed by other individuals as well." Here it is significant to refer to the views of Lord Peirce as expressed in Imperial Chemical Industries Limited versus Shadwell. The doctrine of vicarious liability has not grown from any very clear, logical or legal principles, but from social convenience and justice. It is presumed that the master employs the servant for his own benefit, and being better able to make good any damage which may occasionally result from this arrangement, is answerable to the world at large for all torts committed by the servant within the course of the employment. Dear viewers, the word vicarious is derived from the Latin word vicar, which literally means acting as a substitute on behalf of someone else, as a delegate or under the person's delegated authority. The state in modern times plays a very important role not only in maintaining law and order, but also in promoting the social welfare of the population. However, the concept of the vicarious liability of the state has to be studied from a historical perspective to gain a better understanding with regards to the contemporary times as well. If we turn back the pages of history and place reliance on the common law, the Crown could not be sued in tort either for wrongs authorized by it or committed by the servants in the course of their employment, as emphasized in the case of Canterbury versus Attorney General 1842. The immunity of the Crown from liability did not exempt the servant from liability. The result was that where an ordinary master was liable vicariously for the wrong done by his servant, the government was not liable for a tort committed by its servant. Historically, it was seen that gradually the functions of the state increased and the Crown became one of the largest employers of labor in the country. With the growing functions of the state, the rule of immunity for the Crown became highly incompatible with the demands of justice, and to overcome the shortcomings of the prevailing law and ensure justice, various devices were found. The Crown started the practice of defending actions brought against its servants in respect of torts committed by them in the course of their employment. Gradually, the Crown Proceedings Act 1947 was also passed. Under this Act, the Crown was liable for a tort committed by its servant just like a private individual. Reflecting on the position in India, during the historical period, unlike the Crown Proceedings Act of 1947 in England, India did not have any statutory provision mentioning the liability of the state in India. Here it is important to refer to Section 176 of the Government of India Act 1935. We can also place reliance on Section 65 of the Government of India Act 1858, which provided as follows. The Secretary of State in Council shall sue and be sued as well in India as in England by the name of the Secretary of State in Council as a body corporate, and all persons and bodies of politics shall and may have and take the same suits, remedies and proceedings, legal and equitable, against the Secretary of State in Council of India as they could have done against the East India Company. Dear listeners, in the context of the East India Company, a celebrated case is Peninsular and Oriental Steam Navigation Company versus Secretary of State for India, 1861. In this case, the plaintiff's servant was travelling in a horse-driven carriage and was passing by a road in Calcutta, which was the government's property. Due to the negligence on the part of the defendant's servant, a heavy piece of iron, which they were carrying for the repair of a steamer, fell, and its clanks frightened the horse. The horse rushed forward and collided with the iron, resulting in injury. The plaintiff filed a suit against the Secretary of State for India in Council for the damage that was caused due to the negligence of the servants employed by the Government of India. The court tried to look into the liability of the East India Company. A distinction was drawn between the sovereign and non-sovereign functions of the East India Company. It was held that if the act was done in the exercise of the sovereign functions, the East India Company would not have been made liable, but if the function was a non-sovereign one, that is, one that could have been performed by the private individuals as well, without any delegation of power by the government, the company would have been made liable. Maintenance of the dockyard was considered to be a non-sovereign function, and as such, the government was held liable. Dear listeners, a major effort was made to determine the vicarious liability of the state on the basis of the sovereign and non-sovereign functions of the British East India Company. When an act was done or a contract was entered into in the exercise of powers, usually called sovereign powers, by which we mean powers that cannot be lawfully exercised except by a sovereign or a private individual delegated by the sovereign to exercise them, no action would lie against the government. Another significant case is Naveen Chandra Das versus Secretary of State for India. In this case, the state was exempted from liability when the functions were considered to be sovereign ones. There, the plaintiff filed a suit contending that the government had made a contract with him for the issue of a license for the sale of ganja and had breached the same. The evidence led to the conclusion that no contract existed between the two. Relying on the decision in Peninsular and Oriental Steam Navigation Company's case, it was further held that, assuming that there was a contract, the action could not lie as the act was done in exercise of the sovereign powers. Dear viewers, now we shall reflect on the post-independent position in this context. Here, reliance can be placed on the state's liability as provided in Article 300 of the Indian Constitution. Article 300 of the Constitution of India provides, the Government of India can sue and be sued by the name of the Union of India, and the Government of a state can sue or be sued by the name of the state, subject to any provision which may be made by an act of the Parliament or of the legislature of such a state enacted by virtue of powers conferred by the Constitution, sue or be sued in relation to their respective affairs in the cases as the dominion of India and the corresponding provinces or the corresponding Indian states might have sued or been sued if this constitution had not been enacted. Further, if at the commencement of this constitution any legal proceedings are pending to which the Dominion of India is a party, the Union of India shall be deemed to be substituted for the Dominion in those proceedings, and any legal proceedings are pending to which a province or any Indian state is a party, the corresponding state shall be deemed to be substituted for the province or Indian state in those proceedings. Listeners, from the above, it is very well established that as per Article 300, the Union of India and the states are distinct bodies for the purpose of suit or other legal proceedings. An important case in this regard is of Vidyavati versus Lokumal, 1957. In this case, the plaintiff's husband died after being knocked down by a government jeep that was driven rashly and negligently by an employee of the state of Rajasthan. At the time of the accident, the car was being taken from the workshop to the collector's bungalow for the collector's use. The court held the state of Rajasthan liable in an action against them. The Rajasthan High Court did not find any reason for treating the state differently from an ordinary employer and held that the state of Rajasthan was liable for the wrongdoing of the driver. The Supreme Court confirmed and endorsed the decision of the Rajasthan High Court. Moving on ahead, in the case of state of Rajasthan versus Vidyapati, 1962, the observations made by the Supreme Court may also be noted as follows. In this connection, it has to be remembered that under the Constitution, we have established a welfare state, whose functions are not confined only to maintaining of law and order, but extend to engaging in all activities, including industry, public transport, state trading, to name only a few of them. In so far as state activities have such wide ramifications, involving not only the use of sovereign powers, but also its functions as an employer in so many public sector undertakings, it is too much to claim that the state should be immune from the consequences of tortious acts committed by its employers in the course of their employment as such. However, in the case of Kasturi Lal versus State of Uttar Pradesh, 1965, a different stance was adopted by the judiciary. The Supreme Court in this case again stated that if the act of the government servant was one that could be considered to be in delegation of sovereign powers, the state would be exempted from liability, otherwise it would not. In Kasturi Lal's case, Rusaram, one of the partners of jewellers at Amritsar, happened to go to Meerut, reaching there at midnight on 20th September 1947 by the Frontier Mail. He had gone to Meerut in order to sell gold and silver in the market. While he was passing through one of the markets with his belongings, he was taken into custody by 3 police constables on the suspicion of possessing stolen property, and then he was taken to the police station. During the search, the police discovered that he was carrying 103 tolas of gold and over 2 mounds of silver. He was kept in police lockup and his belongings were also kept in the custody of the police under the provisions of the Criminal Procedure Code. The next day, he was released on bail, and sometimes thereafter, the silver was returned to him. The gold had been kept in the police station Malkhana under the charge of the then head constable, Muhammad Amir. The head constable misappropriated the gold and fled to Pakistan in October 1947. The plaintiff filed an action against the state of Uttar Pradesh, claiming either the return of the gold or in an alternative compensation for the same. The state of Uttar Pradesh was held to be not liable on the grounds that, firstly, the police officers were acting in the exercise of statutory powers, and secondly, the powers of the police officers in keeping the property in Malkhana were a sovereign power. Dear listeners, another area of concern under the concept of vicarious liability of the state is with regards to the acts of police personnel. Can the acts of the police personnel make the government vicariously liable or not? Here we can refer to the case of Asim versus Muhammad Nizamuddin Ahmad, 1999. In this case, the plaintiff was carrying on business in the sale of seeds of different agricultural products such as jute, vegetables and oilseeds. The business was being carried on without a license, which was needed for such businesses. The police authorities seized the seeds from the plaintiff's shop. The seeds got damaged because of lack of storage facilities and negligence while they were kept in the police custody. The plaintiff sought compensation from the state for the damage caused to the seeds during the time they were in police custody. It was held that the seizure of the seeds was in the exercise of the sovereign power, and the plaintiff was therefore not entitled to claim any damages for the same. Dear listeners, another case is that of State of Odisha versus Padmalochan, 1975. The question that had arisen was whether the excesses committed by police personnel while discharging their duties could come within the purview of delegated sovereign functions so as to exempt the state from liability. The brief facts of this case are that there was an apprehension of an attack on the office of the collector and properties by a mob which had resorted to violence there. The Odisha military police, under the control of supervising officers and a magistrate, cordoned off the areas. Police personnel assaulted members of the mob without orders from the magistrate or any higher police officer, resulting in injuries to the plaintiff. It was held that the posting of police personnel in front of the collector's office was in exercise of the delegated sovereign functions. The fact that the police personnel committed excesses in discharge of their functions without authority would not take away the illegal act from the purview of the delegated sovereign functions. Thus, the injuries caused to the plaintiff by the police personnel while dispersing an unlawful crowd in exercise of the sovereign functions of the state made the state liable. Dear listeners, now we will talk about the negligence of military servants and the vicarious liability of the state. As we all know, the maintenance of the army is a sovereign function, but this does not necessarily mean that the state will be immune from liability for any tortious act committed by army personnel. Here also, a difference has to be drawn between acts that could be done by the government in the exercise of sovereign powers and acts that could have been equally done by a private individual. A very important case with regards to military personnel is Srimati Menam Ongbi Beena Devi versus State of Manipur, 2015. In this case, rape was committed by an employee of the Union of India, though the accused employee had not been on duty but on unauthorized leave. The accused was under the rule of the Assam Rifles and while being posted in Manipur was deemed to be in active service not only within the meaning of the Army Act but other laws for the time being in force. Holding the central government vicariously liable for the offence of rape committed by the accused, an employee of the Assam Rifles, the Manipur High Court stated that the accused was on duty in the state for maintenance of law and order, and the said accused abused his position as an armed personnel of the Assam Rifles and also used his service weapon to perpetuate the crime. Though he might have been technically on leave at the relevant time, which would not make any difference to the victim, the court ruled. As a consequence, it was held that the authorities could not escape liability for the payment of compensation to the rape victim. In contrast to this case, we shall now refer to the case of Union of India versus Harbans Singh, 1959. In this case, meals were being carried from the cantonment in Delhi to be distributed to military personnel on duty. A military driver was driving the truck belonging to the military department carrying the meals. It caused an accident resulting in the death of a person. The court held that the state could not be held liable for the accident as it was done in the exercise of sovereign powers of the state. Dear listeners, another important aspect in this context is with regards to the vicarious liability of the state in context of loss to property. When the property is in the possession of the state offices, there is deemed to be bailment of that property, and the state as the bailee has been bound to either return the property or pay compensation for it. In the case of State of Gujarat versus Muhammad, 1967, the customs authorities seized 2 trucks, a station wagon, and goods belonging to the plaintiff on the grounds that the plaintiff had not paid import duties on the said trucks that were used for smuggling goods and that some of the goods were smuggled ones. The custom authority made a representation to a magistrate stating that he is required to claim the said property and dispose of it under the orders of the magistrate. Subsequently, the Revenue Tribunal set aside the said order of confiscation and directed the return of the said vehicle to the plaintiff. The plaintiff claimed back his vehicle or in the alternative, the value of the same. It was held by the Supreme Court that after seizing the property, the position of the government was that of a bailee. The owner's right to demand a proper return of the property was not affected by the order of the magistrate obtained on a false representation. The government therefore had a duty to return the property, and in the event of its failure to do so, it had a duty to pay compensation to the aggrieved person. Dear viewers, in the end, I would like to say that the state in the modern times is no longer a mere police state. People engage in or involve themselves in different capacities in numerous activities carried out by the state. Under these circumstances, there is all the more reason that the state should not be treated differently from other employers in the context of vicarious liability. This approach will also help in serving the larger public interest. With this, we come to an end of today's lecture. Thank you very much.